She did something else? Yeah. Stop.
Good evening and welcome to this evening's Special Board of Education meeting. It's Wednesday, November 6th. Will you please stand with me for a moment of silence and pledge allegiance? Thank you. I pledge
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, so we have one item on our agenda for this evening, but before we get into that, I would like to invite Mr. Shouty, who is the district's legal representative, to speak to us about board policy and meeting expectations. Board meeting expectations.
Thank you. Over here?
Yes, please.
Thank you. Good evening, everybody. Again, my name is Todd Shouty, and I'm an attorney with the law firm of Fletcher, Philco, Shouty, and Francis. We are located in St. Clair County, and we represent quite a few public entities in this county and in the surrounding counties. And we've done a lot of board meetings, and I also specialize in constitutional litigation. I do most of my practice in federal court or federal judges dealing with constitutional issues. After the last meeting, I thought it made sense for me to talk a little bit about the First Amendment and how it works at a public meeting such as this. So, obviously, you're an elected school board. An elected school board conducts business meetings, and that's what this is tonight. It's a business meeting. Your job is to conduct the business of the school district. Under state law, these meetings are done in the public. It's what they call an Open Meetings Act. Requires that we do these meetings in the public, so the public has an opportunity to see us conduct this meeting and what happens at these meetings. A lot of people confuse, what happens when they come to a board meeting. They think that it's an open public forum. They can speak whatever they want, say whatever they want, and talk about whatever they want, and that's protected by the First Amendment. But that's not the way it works at a business meeting like this. This is what's called a limited public forum. So under the First Amendment, people have a right to speak, but they only have a right to speak according to the rules of the forum. So you have rules in place, bylaws that are on your website, which specify that you have a public audience period, an opportunity for people to speak. That's an opportunity for people to speak and exercise their First Amendment rights during that period. That is actually a provision that's required under the Open Meetings Act, and we give people an opportunity to speak. When they speak, it has to be subject to our rules. We have the right to pass reasonable rules to restrict it. We can restrict to when people speak, when the public speaks. We can restrict how long they speak, and we can restrict and limit them to the topics at hand. We have the right to limit it, that it's not an open public forum for people to say and talk about anything. So if you look at our rules, we have that specifically in there. And we say, except during a public participation portion of a board meeting, no member of the public or other person may address the board during a public meeting without the express permission of the president or other presiding officer. Somebody else is presiding at the meeting. So basically the way it's set up, and this is very common, you guys have rules that are pretty much the same in almost all public entities. And that is, you have an open, a public comment period. People get to say their opinions on things that you can consider. And then after that, you go into the business part of your meeting. And during the business part of the meeting, you conduct your business. There may be times when you're dealing with a topic where you want to hear from somebody from the public. That would only happen if the board recognizes that person and invites them to speak. Those same rules apply to me. Like, I don't have the right, even though I'm designated legal counsel, to just blurt out and talk or say anything I want. I can only speak if you invite me up here to speak, and that's what you've done today, so I appreciate that. So, what's happened is from time to time, we get a little loose with our rules, we get a little informal, and that's very natural, because you're trying to conduct business, you're trying to find things, find out what's going on, people have questions, people do want to hear from the audience, but if we want to do it that way, we should go to the, request permission to speak to the board chair, and then ask the board chair to recognize someone, and then the board chair controls the meeting and just makes that decision, okay? So that's the way it's supposed to work. It should not be a situation where people from the audience yell out, and we have in effect, someone yelling and other people yelling, and then it's hard to, conduct business in that environment for anybody. That's a bit of mob rule, if you will. So if we have that type of situation, I know at the last meeting, we had that type of situation. I just saw a very brief part of a video, and I know that the board chair used the gavel to try to stop somebody from talking, and that's the way you're supposed to do it. And your rules really say how I always recommend public entities do it, and that is if somebody breaches the rules, you gavel them down and you let them know what the rules are, so they know, and you give them a warning. And if they then continue to violate the rules, at that point in time, you would ask them to leave. And if they don't leave at that point in time, you could ask for help from law enforcement for them to leave. That's kind of the steps that you would go if somebody is disrupting your meeting and not following the commands of the chair. So your rules kind of say that. Says a person who persistently engages in disorderly conduct or otherwise breaches the peace at a board meeting after notice from the president or other presiding officer may be removed. And that's really the best way to do it, is let somebody know. They may not know that the rules don't allow them to speak out of turn. Let them know. Then if it continues, then we might have to have them removed. Now, technically there is a state criminal statute that prohibits people from disrupting meetings. And people can be charged with a misdemeanor if that happens. We have law enforcement present here tonight, and law enforcement officers, if they see a breach of the peace at a public meeting themselves, they have the right to actually arrest somebody under Michigan law. However, the way it should work, in my opinion, is if somebody's going to be removed from the meeting, it should be at the direction of the chair after we go through the warning procedure. Okay. So that's how it's supposed to work. I understand people get passionate about these issues. I understand that people care about what happens at the school district where their kids are going to school. Very understandable. But again, this is a business meeting, and at a business meeting, there's certain decorum expected of people, and that is you only speak when you have permission to speak. You go ahead and express your viewpoints. You have passion, and you want people to know that passion, that's fine, within reason. And express your opinion, and then it's time to sit down. If somebody wants to be recognized from the audience on a topic that comes up later, they would have to seek permission from the chair to speak, okay? The chair would have to see them, recognize them, and then say, okay, let's hear from Mr. Smith, so to speak, okay? Whoever the person is. And you might be involved in some business item where somebody has some personal knowledge that you want to hear before you make a decision. And that's perfectly fine. But I just wanted to kind of spell this out so everybody had a basic understanding of how it's supposed to work. And hopefully we can return to that process so that you guys can do your business and make your decisions and make informed decisions without people shouting at you or yelling at you, that type of thing. Okay. Are there any questions?
Do you have any questions for Mr. Shelby?
Okay. Yeah, it's very common, and it's become very common today that people, speak, they record what happens at the meetings, they put it on social media. That's very common, happening all over the country, Okay, that's fine, they can do that, but we also have a business meeting to conduct, we have to get to our items. Okay.
Thank you very much.
All right, thank you.
Thank you. Okay, so right before we go into public comment, I would just like to say why we are here. We are here to address a retaliation complaint appeal. We are not here to evaluate anybody, and so that is the topic for our agenda this evening. I would also like to let it know that Ms. Gardner requested the meeting be postponed until our December meeting, saying she had a conference, jury duty, and needed time to prepare. The request was denied because of several reasons. First is that our board policy that was in effect at the time the complaint was filed states that the decision to be made is to be made within 30 days. I think we're a little bit past that at this point. The conference was last weekend, and if she needed to go to jury duty, she would hopefully be done with jury duty by 6 o'clock. The other important thing to remember about postponing the meeting is she had ample time to prepare for this evening. She filed her complaint on September 16th, and then she filed for the appeal on September 23rd. So we feel as though she had ample time to prepare for this evening's meeting. So she has, chosen not to attend this evening. But now we will go into our public comment portion of the meeting. I think Mr. Shouty explained the rules, how everything should be followed. So I have one green card. Is there anybody else that would like to address the board? Okay, Alan Richley, if you would just.
Okay, so just really quick, I wanted to correct something. For some odd reason, I had like a gut feeling, so I brought this with me. But this is an article from 2022. It says,
Mr. Richley, your 5 minutes is up now for your public comment. Are you addressing the board now?
Yes.
Regarding that? Okay,
Yes, correct.
Okay.
So it says a citizen cannot be thrown out of a public meeting simply because he or she offends, antagonizes, or harshly criticizes a government body or members of a governing body during a public comment period. The court ruled, skipping ahead, the court ruled, Eisen versus Madison Local School District Board of Education, that the school board's policy prohibiting personally directed, abusive, and antagonistic comments violated free speech rights under the First Amendment. So I understand things kind of got a little bit out of hand at the last meeting, but also, and the attorney claims that he only watched a snippet of it. Well, you guys violated the law, which almost violated the law with your attempted closed session. So I'm going to get to that. But I want to preface this by saying that these words are all my own and no one knows what I'm about to say. But over the last few weeks, I've talked to many people that I've graduated with and many people with children that have had Mrs. Gardner as a teacher. Believe it or not, many of you may not be aware that I'm a frequent critic of the school district. Believe it or not. But and so when I say something good, you better listen. Hiring Lori Gardner as a teacher was probably the smartest thing that they ever did. I only had her as a substitute teacher when I was in school, so she was just starting out. But she left an impression on me and many others, which is saying something, as most subs are glorified babysitters. She stuck out to many people in that sense. I have a pretty good memory, and I recall a lighthearted argument that Mrs. Bebuck and Mrs. Shagney were having over who was going to have her as a substitute teacher. She covered many teachers over that time, and I know for a fact that she's touched many lives as a teacher, and she has been nothing short of professional, and in my view, the very model of what a teacher is supposed to be. What transpired at the last meeting was nothing short of egregious. The superintendent calling out an employee by name in public, the president of the board attempting to illegally hold a closed session and ambushing an employee. Lost my spot. Not to mention the very strange recess and disappearance of Sherry Becker. I don't even know who that is, but many people talked about it. The fact is, you have to post on the agenda ahead of time that there's going to be a closed session in order for it to be compliant with the Open Meetings Act. You all need to educate yourselves on that. Ignorance is no excuse. You also did not state the reason why you were going into closed session in the first motion, which is also wrong. Jeannie, you should know better by now. Thank you to Mr. Westrick and Mrs. Cedar for asking good questions and postponing that train wreck. Dustin DeSnyder also deserves a lot of thanks for standing up and calling out the BS that was being spewed. I thought that there was a no bullying policy in place. If that's the case, then why are people bullying a school employee during a board meeting? That's not setting a good example for kids in the district. The way that you know this is ridiculous is that myself and Libby Prill, who we both used to be critics of each other, we both agreed with, how ridiculous it was. But as ridiculous and as egregious as that all was to witness, what's even more egregious was the lack of representation from the union, which apparently they were in the audience, and I couldn't believe that they wouldn't stand up against what they were seeing. I found that disgusting, and it has me asking, what the heck's the point of a union at that point? I think Mrs. Frank is the only board member that can remember the story, but remember the teacher we had go through a disciplinary hearing, and there were issues galore from that. From accusations of sexual contact with a student to stealing money. Not only was their name never mentioned publicly at a meeting, but they were defended by the union 100%. In the agenda, there was simply an employee/teacher number, their name never mentioned, or what they were accused of. How is it that teachers like that are defended, but a good teacher is not? Tonight, you as a board have the opportunity to do the right thing and defend a great teacher from bullying. I've heard that there's some good board members, and if that's true, now is the time to take a stand. This decision could not be clearer. Do the right thing and support your policy of no bullying. Stop publicly calling out a teacher of yours and maybe try supporting her the way that she supports the district and the children that she teaches. I always hear people say it's for the children, it's for the kids. Put the children first. Well, it's time to prove it. Thank you.
Anybody else? Okay, so at this time, in order to open the discussion, a motion is needed to reject the employee appeal from 2024-01. Support. Okay, so that will open up the discussion. If Mr. Shouty would come back up here and explain to us the process in which we went through to investigate the retaliation complaint appeal.
Thank you. Just to be clear, what we're here tonight to do is for the board to make a decision on an appeal of a denial of a complaint that was filed by an employee. Your policy that existed at the time gives employees the right to make a complaint. That's been reviewed by the district, and if the employee doesn't like the decision by the district, they have the right to appeal it to the board. And so that appeal is before the board, and it's, this is not a decision as to whether or not to discipline a teacher or anything like that. It's the decision as to whether to grant or reject an appeal on a complaint that was made. So if you look at this historically, a number of months ago, I believe it was in June, this board directly received a complaint, the same type of complaint, a claim of retaliation. This board investigated it, determined that there was no retaliation. An appeal was taken to this board. This board then reviewed the appeal, and the claims in there and rejected it. Now we have another complaint has been made basically over the same issue. The initial case was over some discipline. Part of that discipline included a performance improvement plan. The union, who is the exclusive bargaining agent for teachers, including the teacher involved here, was agreed during the grievance process to specific discipline, and that discipline included a performance improvement plan. So that was March 15th. It was confirmed by email, which has been provided to the board. The complaint then that came in this time was a complaint saying that that performance improvement plan that had already been agreed to back in May was in retaliation for an email in September of 2024, September 10th. And that was a performance improvement plan that was already in place. So, if you look at the facts, it appears there was also a meeting with the union in August of 24 to go over this. The union requested that the performance improvement plan be made part of the growth plan and not be given to the teacher until the beginning of the school year, after the school year had started. And that's what happened. So as I see it, the only way the September 10th, 2024 email could be the reason for the performance improvement plan is if the original performance improvement plan that was in place in May, discussed in August, there was somehow some decision not to give it to the employee, and then this email then prompted the performance improvement plan to be reinstated, and I don't see any evidence to that effect. I didn't see anything that would support that. In fact, it appears that it's been in the works from the beginning, and it's something that was in the works and already agreed to at the time you rejected the first retaliation complaint. So as I see it, your decision tonight is whether or not you grant or reject the appeal. And that's really the only issue. So the teacher involved is already on a performance improvement plan. I think it's fairly simple and straightforward. So it's in effect, so it's not, we're not looking at, the only issue is whether or not we grant the appeal or reject the appeal.
Thank you. Does the board have any questions for Mr. Shelby?
Yeah, can you tell everyone what your legal opinion was about that?
Yeah, so if you look at just straight case law, how retaliation works, retaliation has to be like the cause, but for cause of the event. So the event claimed that you gave me a performance improvement plan, so it has to be caused by the email. And the problem is the performance improvement plan was already in place beforehand, so it wasn't caused by the email, as I said, unless something happened in the meantime, which I didn't see any evidence and nobody's claimed that's happened. You understand?
I understand what you're saying, I just want to make sure everybody
Sure.
did, because we've all read your opinion. And this would be a question for after, but we'll adjourn after. Do you see any way we can amicably make this all go away? I mean, I don't.
No, I think the key, like, I thought you should go forward with the meeting tonight just so that there's clarity on this issue, right? Because if you have a teacher who's working on a performance improvement plan, the semester's active right now. And I think the request was to move it to the end of December, that would basically be the end of the first semester. So I would want there to be clarity so the teacher knows what I'm expected to do, that has a chance to do it and demonstrate they can. And it looks like they're fairly simple, that they could easily do that.
Thank you.
So hopefully it is done and it will be amicably resolved by them completing the performance improvement plan, and we'll all move on.
So the only thing we're voting on is whether or not there was retaliation. The reason for the PIP was retaliation, but the request, that was before any, so it couldn't have been. There's no way we could vote that was the case.
Well, just from a logic standpoint, you're absolutely correct. From a logic standpoint, it couldn't have been the cause of it. As I said, unless there was some decision in the meantime to change and say, we're not gonna do a PIP, and then we reinstate.
But we're not voting on anything with the PIP, just that retaliation.
Yes.
Okay.
Yeah, that's what's before.
Okay.
Are there any other questions? Okay, so we have a motion on the table to reject the employee appeal of 2024